So everybody's freaking out about the potential $42,350 fine per video that the FTC can impose on content creators for violating the terms of COPPA, the Children Online Privacy Protection Act. And the question I'm asking myself is, do the terms of COPPA even apply to content creators? And the answer is, if I told you now, you wouldn't stick around to watch the rest of this video now, would you? Viva Frei, Montreal litigator turned YouTuber, and right now anybody who is remotely familiar with YouTube as a platform, especially content creators, are freaking out at the prospect of being fined upwards of $42,350 per video that violates the terms of COPPA, the Children Online Privacy Protection Act, if it is directed at children and not designated as such. And I made a couple of videos on this previously, I'll link one right here. But in the middle of the night, Saturday night, I sit there wondering, why would the terms of COPPA even apply to content creators in the first place? But before we even answer that question, we have to go back to the beginning. 1998 COPPA, or the Children's Online Privacy Protection Act, comes into effect. 1998 is in the infancy of the internet, and the purpose of the act was to regulate and prohibit gathering information on children. Fast forward over 20 years, and the FTC, the Federal Trade Commission, files a complaint against Google and YouTube on the basis that Google and YouTube were violating the terms of COPPA. The essence of the allegations against Google and YouTube is that they were violating the terms of COPPA by gathering information on children, that being persistent identifiers to allow for targeted marketing. As fast as the complaint was filed, it was settled by Google and YouTube, who agreed to pay $170 million, which apparently represents 2 days of profit of Google, and to implement a system that would ensure that they no longer violate the terms of COPPA as relates to gathering of information, that being persistent identifiers for marketing on children under the age of 13. But where did this concept of persistent identifiers even come from? And to answer that question, you have to go back to a 2013 amendment to the 1998 COPPA rule. What was the essence of the 2013 amendment? For release, July 1st, 2013. The revised COPPA rule addresses changes in the way children use and access the internet, including the increased use of mobile devices and social networking. The modified rule, approved by the Commission in December 2012, widens the definition of children's personal information to include persistent identifiers such as cookies that track a child's activity online, as well as geolocation information, photos, videos, and audio recordings. And then going back to December 2012 for further clarity on what the amendments mean. For release, December 19th, 2012. The final amendments modify the list of personal information that cannot be collected without parental notice and consent, clarifying that this category includes geolocation information, photographs, and videos. Extend COPPA rule to cover persistent identifiers that can recognize users over time and across different websites or online services, such as IP addresses and mobile device IDs. Require that covered website operators adopt reasonable procedure for data retention and deletion. The definition of an operator has been updated to make clear that the rule covers a child-directed site or service that integrates outside services such as plugins or advertising networks that collect personal information from its visitors. The definition does not extend liability to platforms such as Google Play or the App Store when such platforms merely offer the public access to child-directed apps. The definition of a website or online service directed to children is expanded to include plugins or ad networks that have actual knowledge that they are collecting personal information through a child-directed website or online service. So as we see, even according to the FTC, the rules of COPPA only apply to operators. How then can content creators be deemed to be operators? Damn it. Okay, so how is operator defined under COPPA itself? You will find the COPPA rule in its entirety at 16 CFR, Charlie Foxtrot Romeo, section 312. In the rule, you will find definitions such as the definition for operator. Operator means any person who operates a website located on the internet or an online service and who collects or maintains personal information from or about the users of or visitors to such website or online service, or on whose behalf such information is collected or maintained, or offers products or services for sale through that website or online service where such website or online service is operated for commercial purposes involving commerce among the several states or one within... what are we talking about here? The definition gets a little irrelevant to the end, sticking to the essential. An operator means anybody who operates a website on the internet. In the internet? Within the internet? Anybody who operates a website on www. And here is the kicker, or on whose behalf such information is collected or maintained. Now, the obvious argument is going to be that content creators or YouTube channels are not operators because they do not own the website on which their videos are located. The argument is going to be that the content creators or YouTube channels do not collect or maintain data on users or visitors to YouTube. However, there may be an issue with the third element of the definition of operator, that being for and on behalf of whom information is collected or maintained. And presumably the argument there is going to be that content creators or YouTube channels nonetheless satisfy the the definition of operator under COPPA, in that although they are not the ones collecting or maintaining the data, it is being done for and on their behalf for the purposes of directed ads on their videos. Now that is just an argument, and I should qualify this as saying that nothing in this video constitutes legal advice by any means whatsoever. If you have any questions on this, you need to consult an attorney in your proper jurisdiction who can analyze your situation based on your specific set of facts. And this is not even necessarily my opinion, this is just an expose of the state of the facts as they currently exist and whether or not YouTube channels and content creators satisfy the definition of operators under COPPA such that they are subject to the rules of COPPA itself. So now at least we understand one of the aspects of the argument, but this is not really where all of the panic is coming from as relates to the FTC treating content creators and video makers as operators under the law, subject to a potential fine of $42,350 for every video that violates the terms of COPPA. The panic comes from the fact that the FTC in their press conference in 2019 to announce this settlement with YouTube actually confirmed that they might in fact go after content creators and YouTube channels that create child-directed content. Reading the provisions of COPPA and listening to this press conference, I myself was wondering where the FTC got this authority. And it stems back to a 2015 FTC complaint and settlement against two companies, LAI Systems LLC and Retro Dreamer. In the complaint, it's alleged that LAI Systems and Retro Dreamer violated the terms of COPPA, and how did they do this? They designed apps that were directed at children, were free to play, and were downloadable from the Apple App Store, Google Play, and Amazon apps. The companies themselves were not operators in the strict definition under COPPA, nor did they personally collect or maintain any data on their users. So how did the FTC deem them to be operators under the law? Well, it's described in the complaint itself. First, just to go over the criteria that the FTC is using to determine if content is child-directed. For example, LAI's Kids app contain brightly colored animated colors including dogs and children, and involve only simple play. Their subject matter, which includes creating images of cakes and pizzas, playing dress-up, hairstyling, and learning animal sounds, would be highly appealing to children. In addition, as described above in paragraphs 13 through 18, and as shown in exhibits B through G, the language used to describe the apps in the app stores is simple and would be appealing to children under age 13, and in some instances identify children as their target audience. Now, there are a ton of videos on YouTube addressing the specific question, how do I know if my content is child-directed? One of the most thorough, in fact, is a video done by Nate Brody on the subject, and I'll link it right here. Give it a watch, it's a good one. All that to say is I'm not going to specifically address them in this video. They're all over the internet and on the FTC website themselves. They are open to interpretation, which is precisely part of the problem, but I digress. How did the FTC file a complaint against these two companies who were not technically speaking under the strict letter of the law operators, and who were not themselves collecting or maintaining data on their users? Through the kids' apps, defendants allowed third-party advertising networks to collect personal information in the form of persistent identifiers. Now think back to the 2013 amendments to the COPPA rule. In order to serve targeted advertising on the app based on users' activity over time and across sites. Defendant did not inform these third-party advertising networks that the apps are directed to children and did not instruct or contractually require the advertising networks to refrain from targeted advertising. This matter never went to trial. No judge ever ruled on the legitimacy of the FTC reasoning, and agree or disagree with the FTC reasoning, that is it. Since the 2013 amendments to the COPPA rule to include persistent identifiers, the FTC is operating on the basis that they can expand the definition of operator to include individuals that are neither the owners of the website nor the ones actually collecting or maintaining data on the users, insofar as they allow third parties to collect and maintain such user data for the purposes of targeted ads in violation of the 2013 amendments, which relates to persisting identifiers for the purposes of targeted ads at people under the age of 13. And although this particular complaint and settlement relates only to an app designer, the theory is that it applies mutatis mutandis to content creators and video creators on YouTube. In the LAI complaint, LAI allowed third parties, presumably Apple, Google, and Amazon, to collect and maintain user data on children under the age of 13 for the purposes of targeted ads. The targeted ads at the users of the app are precisely what generated the revenue for LAI Systems and Retro Dreamers. And the complaint and settlement is based on the fact that these two companies knew that third parties, Apple, Amazon, and Google, were collecting data on their users, and they did not notify them that their app was directed at children under the age of 13. Now apply all of this to content creators and video makers on YouTube. Targeted ads are the most lucrative form of revenue generated through AdSense revenue on YouTube. And the FTC stating that they may go after content creators and YouTube channels that create child-directed content are going to apply the same reasoning mutatis mutandis. If you make child-directed content on YouTube and you do not notify YouTube that your content is directed at children, YouTube may collect and maintain data on the viewers of that video for the purposes of targeted marketing on that video, such that the video creator or YouTube channel, even though they don't own YouTube and even though they're not the ones collecting and maintaining the data, can be deemed to be operators under under the definitions of COPPA. I'm not saying I agree with it, that is just the reasoning. And there are a ton of YouTubers that are in a panic and deleting or making private a ton of old videos. Content creators are freaking out that they're going to end up with $1 million fine because they have 25 videos that the FTC deems to be child-directed. This is not legal advice, this is just my experience of having been a practicing lawyer for 13 years. I don't think it's entirely realistic that the FTC is going to come down with the iron hammer for the max penalty for each and every violation. Even operating on precedent from previous FTC complaints, they generally speaking really only go after the big violators. They may issue warnings, they may issue small fines to small channels that have 500 views on a video that they deem to be child-directed, but I don't think we're going to be living through a doomsday scenario where the FTC is going to come in and issue tens of thousands of dollars of fines for each and every video that it deems to be child-directed content that was not flagged as such under the new rules that come into effect in 2020. Now, I said at the beginning of the video that I would answer the question as to whether or not COPPA even applies to content creators. Now that you know the facts, you can come to your own determination, but the bottom line is the only reason it would matter if COPPA actually applies to content creators is as relates to fines that can be issued by the FTC. As relates to what's going to happen on YouTube as of 2020, it actually doesn't matter if COPPA doesn't apply to content creators. And so even if the courts determine that COPPA does not actually apply to content creators or YouTube channels, the rules on YouTube are going to require content creators to identify their videos as either being directed at children under 13 or not. And if you break those rules, the FTC might not issue a $43,000 fine, but YouTube sure as heck is going to sanction that conduct. For right or wrong, YouTube is probably going to shut down channels that are routine violators or routinely misflag their videos. For right or wrong, YouTube is just not going to risk it any longer with channels that do not properly flag their videos so that YouTube knows not to collect data from them in violation of the rules of COPPA. And there's an amazing video out there by another YouTube lawyer named Ian Corzine who says that he got a call on a Friday night from an unidentified number from a person who refused to identify themselves, saying that YouTube was aware of a problem whereby it's not actually true that the only two alternatives as relates to videos is directed at children under 13 or directed at people above 13. Apparently YouTube was aware of the fact that the FTC had a third category which relates to mixed audiences, as relates to videos and content that is not specifically directed at children but might include children just as an incidental to the content. And the FTC itself identified what is being referred to as a mixed audience. And according to the person who relayed this information to Ian Corzine, the reason why YouTube didn't implement this sort of middle ground mixed audience was that it would cost too much money to do so and it would decrease their bottom line profits. Now, I don't really care to get into that. My only impression is that I don't think it would change much as far as anything goes. The mixed audience would not be a separate category, it would just be an exception to the child-directed content. The reality is that people are probably not going to want to take that chance even if the third option were given. And for everyone's general information, there is a massive movement to put pressure on the FTC and YouTube not to implement rules that might very well kill the platform. Another YouTube lawyer who has a channel called Vlawg just did a video with Daryl Eves where they went into detail about all of these issues. I'm gonna link that video right here. Give it a watch, it's very informative. It's an hour long, but if you watch it at 1.75x, it's a lot faster. And all that to say, if you like my video and you like my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below if you want to support the channel because I greatly appreciate any support. There is a PayPal link up in the banner of the channel, and I included below with links to merch. And because it has actually never been more contextually appropriate, don't panic, keep calm, vlog on, and peace out. Booyah.